Arunima Jha, Head of Legal at KnowledgeWorks Global Ltd. It's great to be here today to talk about a topic that's both essential and increasingly relevant: legal strategies for technology startups which are expanding globally. As Benjamin Franklin wisely said, by failing to prepare, you're preparing to fail. This rings especially true for startups who are looking to scale internationally. While innovation and ambition they drive global growth, having a well-defined legal strategy is the key to navigating the complexities of cross-border expansion. The moment an Indian tech startup steps beyond domestic borders, it encounters a maze of international regulations, compliance requirements, and operational risks. Without a structured legal approach, a promising opportunity can quickly turn into a regulatory challenge. So as an Indian startup, when you're venturing into an international market, you must address 5 critical legal aspects: corporate structuring, foreign exchange, compliance, IP protection, data privacy laws, and international contracting. Understanding that these are the legal pillars will ensure that as a startup, you're not only scaling efficiently, but also mitigating legal risks and safeguarding long-term sustainability. The first step in this journey is choosing the right corporate structure. A startup looking to establish its presence in foreign markets must carefully decide whether to set up a foreign subsidiary, a branch office, or a holding company in a startup-friendly jurisdiction, such as Singapore or Delaware in the US or the UAE. So, because each structure has a different tax implication, they will have their own investor expectations and also compliance requirements. The Companies Act of 2013, particularly Section 379, outlines the applicability of Indian corporate law to foreign entities with Indian business interests. Making the right structural decision is not about operational ease. It is also about determining the startup's ability to attract global investors and optimizing your tax liabilities. Next, as a startup, you must ensure that you are complying with the Foreign Exchange Management Act and RBI regulations. When you are going for overseas expansion, it will involve certain financial transactions which will be across borders, and these would fall under strict regulatory scrutiny. FEMA rules regulate how Indian startups should invest abroad, while FEMA's ODI guideline will ensure that any funds which are remitted abroad would have to comply with RBI reporting norms. Again, there are transfer pricing laws under the Income Tax Act, which also govern financial transaction, which is between an Indian parent company and its foreign subsidiary. A lack of compliance in these areas can result in financial penalties, restrictions on overseas investments, and tax complications. Startups must engage in meticulous planning to structure foreign transactions efficiently and remain within the regulatory framework. Beyond financial compliance, to be honest, the IP protection is fundamental for technology startups. As they expand, ensuring you have the global patent, trademark, and copyright security, it becomes a non-negotiable priority for these startups. The Indian Patent Act of 1970, particularly Section 39, restricts patent filings abroad without prior permission from the Indian Patent Office. Many startups opt for patent cooperation treaty filings to secure protection across multiple countries with a single application. Similarly, trademark registration under the Madrid Protocol enables a startup to protect their brand and identity in various jurisdictions. The Trademark Act of 1999, particularly Section 29, defines trademark infringement, which is again very critical when entering international markets. When adequate IP protection, without adequate IP protection, as a startup, you will risk infringement lawsuits, brand dilution, and potential financial losses. Implementing strong confidentiality agreements, technology licensing, cross-border IP agreements, these are just essential to safeguarding your innovation and proprietary technology. Another key area of concern is data privacy and compliance with global regulations. Now, with countries which are adopting stringent data protection laws, Indian startups must comply with GDPR, CCPA, and India's own Data Protection Act of 2023. Section 17 of the Indian DPDP Act governs cross-border data transfers, which makes it critical for startups handling international user data. GDPR's requirements around user consent, data portability, and breach reporting can also have significant legal and financial implications if not adhered to. Fines under GDPR can also go up to 4% of annual global turnover, which makes compliance a business imperative. To mitigate risk, startups must invest in a well-structured privacy policy, strong data encryption measures, and cross-border transfer agreements which are aligned with international best practices. A prime example of GDPR non-compliance is the record £91 million fine which was imposed on Meta, formerly known as Facebook, by the Irish Data Protection Commission for improperly storing user passwords. Additionally, international contracting and dispute resolution mechanism also play a very crucial role in securing business interests across multiple jurisdictions. The Indian Contract Act, particularly Section 10 and 23, governs enforceability and legality of contracts. For startups engaging with foreign investors, clients, or partners, cross-border contracts must include clear jurisdiction clauses, indemnity provisions, and intellectual property protection measures. Many Indian startups prefer international arbitration over traditional litigation, which is, given the complexities of foreign court system. The Arbitration and Conciliation Act of 1996, particularly Section 48, facilitates the enforcement of foreign arbitral awards in India under the New York Convention. Choosing the right governing law and dispute resolution mechanism ensures that your contractual rights are enforceable in foreign jurisdictions, protecting you as a startup from legal uncertainties. Finally, as a startup, you must address your taxation and compliance framework in foreign jurisdiction. Many startups which are expanding globally face challenges related to double taxation, transfer pricing, and also permanent establishment risk. The DTAA, also known as the Double Taxation Avoidance Agreement between India and various countries, allows businesses to offset tax liabilities and prevent dual taxation. Therefore, compliance with GST laws, foreign withholding taxes, and corporate tax structures are essential for a sustainable international operation. Legal teams must work closely with tax consultants to ensure that there is a proper tax planning, foreign exchange hedging, and regulatory reporting to prevent financial liabilities. To conclude, global expansion, while it presents immense opportunities for Indian technology startups, it also brings certain legal challenges. A well-structured legal strategy covering your compliance, IP protection, data privacy, and cross-border contracts are essential for long-term success. My advice to legal counsels and practicing lawyers: your role is very clear. Guide startups through foreign regulations, optimize corporate structures, and safeguard their innovation. Companies like Infosys, Freshworks, and Zerodha have successfully expanded internationally by focusing on a strong legal framework. As more Indian startups go global, compliance will remain the foundation of sustainable growth. Let's continue to support this expansion with strategic legal insight. Thank you.